Hello everyone, today I will discuss the concept of accomplice with you. We come across the term accomplice in the Indian Evidence Act as well as CRPC. Okay, uh, in criminal trials, there is a role of an accomplice to play. And what is that role? I'll be discussing it today. I'll be discussing the relevant provisions of Evidence Act and the relevant provisions of CRPC as well. Okay, so first things first, what is the meaning of accomplice? Accomplice word has not been defined anywhere, although it is used, but it is not defined anywhere. Neither the term approver is defined. Although the word approver has not been used, but if you see the various high courts and the Supreme Court, interchangeably has used the term approver and accomplice. Okay, now uh, what is the meaning of the term accomplice? See, accomplice is a guilty associate, or in simple language, we can say it's a partner. He or she is a partner in crime. Okay, he is so involved with the criminal act that he is also guilty of the act. Okay, the bystander cannot be an accomplice. Okay, just because the bystander is seeing in front of his eyes that the offense is being committed and he is not informing the police doesn't make him an accomplice. Accomplice has an role in the criminal act. Okay, you may find the description of accomplice in a case called Govinda Balaji versus Emperor. Okay, that's an old case, AIR 1936. Okay, now what role does an accomplice has to play in a criminal trial? Accomplice gives the testimony, he gives his evidence with respect to the commission of the crime, what happened and who's guilty. Now, uh, since we know that an accused is also a partner in crime, so how can he give the evidence? Because an accused can give evidence only for his defense, he cannot become a prosecution witness. So what happens is, there are provisions in CRPC wherein the co-accused is given the pardon. Okay, and then he becomes the approver. See, accomplice either should not have been charge sheeted, or if he's charge sheeted, if he's made accused, he should have been either given pardon or discharged, or he must be acquitted so as to be able to give an evidence in favor of the prosecution. Okay, that's very important. Either he is not charge sheeted at all, or he is given pardon under 306 or 307 of CRPC, or if at all he is made co-accused, then he is either discharged or acquitted. Then only he can give evidence. Okay, now how the pardon is given and what is the procedure? This is a little complicated. I'll try and make things simpler. See, under 306 and under 307 of CRPC, and a person who's privy to the crime is given the pardon, and that person is called accomplice, but the accomplice word is used in the marginal heading. If you read the section in detail, they have in detail used the words the person who's either privy to the offense or who's involved in the crime, or who knows, who has been the partner. Okay, now there is a difference between 306 and 307. Okay, before discussing in detail 306, let us just in a nutshell just see what happens when the case comes to a magistrate. Ordinarily what happens is, even if it's a grave offense or any offense, the matter goes to the lower magistrate. Okay, so what he does, what does the magistrate do? He, if the offense is triable by him, he'll commence the trial. If he sees he cannot try the offense, if for reasons, different reasons, I'll not go into the reasons, if he'll see that he cannot try the offense, he commits the case to the court of session. If the offense is exclusively triable by the court of session, and if the offense is not exclusively triable by the court of session, and still he sees that there are grounds that he cannot try the case himself, what he will do is he will commit it to the chief judicial magistrate. I think this is clear. Okay, that is done under the relevant provisions. Okay, I'll not go into the detail, but you will see it's section, please do read section 209 of CRPC. Okay, now when the magistrate sees that there is a co-accused, or there is a person who was the partner in crime, I'll call him an accomplice. If the accomplice is ready to be an approver, okay, is ready to disclose all the facts of the case, all the happenings, then what does the magistrate do? The magistrate gives him pardon under 306. And then if he feels that he cannot try the case, then he commits. So in 306, the pardon is given before the committal of the case. Okay. In 307, the pardon is given after committal of the case. Okay, I'll come to 307 after a while. Let's concentrate on 306. Okay, so in 306, who can give pardon? 3 classes of magistrates are mentioned there. Magistrate of the first class, CJM, that is Chief Judicial Magistrate, and the Metropolitan Magistrate. Okay, so these 3 are empowered to give pardon. लेकिन सबके पास एक सी पावर नहीं है. The Chief Judicial Magistrate and the Metropolitan Magistrate can give pardon during the course of investigation as well. Okay, and the Metropolitan Magistrate can only give the pardon in case of inquiry and trial. Of course, Chief Judicial Magistrate and Metropolitan Magistrate can give pardon in all the 3 scenarios: investigation, inquiry and trial. But the Metropolitan Magistrate, the Magistrate of the first class can give pardon only in case of inquiry and trial, and not during the investigation. Okay, I think this is clear. Now, for what offences the pardon can be given? Pardon can be given for certain offences only. In certain cases, not all the cases. Pardon can be given for the offences which are either exclusively triable by the court of session, or they are triable by a special court or a special judge, or for the offences which carries the punishment of imprisonment up to 7 years or more. Okay, offences which are punishable with imprisonment up to 7 years, and offences which are punishable for a severe punishment, a more severe punishment. Okay, in these scenarios only pardon can be given. Okay, I hope this background is clear, that who can give pardon and for what offences the pardon is to be given. I hope these 2 things are clear. Now, when the magistrate is giving pardon, he has to record the reasons in writing. Okay, means the order of giving pardon must be a speaking order. Speaking order means, speaking order वो होता है जहाँ पे the reasons are recorded in writing. Okay, that is an essential ingredient of 306. Now, pardon ho gaya. Now the examination of the accused. Oh, sorry. Yeah, examination of the accomplice or approver. See, we have seen in section 209 and relevant sections कि जब magistrate के पास mat case आता है and the magistrate commits it, what does the magistrate do? How does the magistrate commits? Magistrate complies with the provisions of 207 and 208, that is providing documents to the accused, relevant documents to the accused. Okay, so with 207 and 208 के provisions comply करने के बाद he commits the case. Okay, now इस scenario में, जिस scenario में there is a accomplice who's ready to become an approver, what will the magistrate do? The magistrate will give him pardon and then before committing examine him as a witness. Okay, this is a deviation from the normal course. Normal course में the magistrate before committing does not examine the witnesses, but here when the magistrate is giving pardon to the accomplice under 306, what does the magistrate do? He examines him as a witness and then commits the case, जिसको भी उसको करना है, either court of session or chief judicial magistrate, जिसको भी उसको commit करना है. What is the idea behind this provision? See, the idea is that before the case is committed, the witness, the testimony of the accomplice as a witness is recorded so that बाद में उसका corroboration किया जाए. मीनिंग कि सबसे पहली टेस्टिमनी, सबसे पहला एविडेंस accomplice का लिया जाए. Okay, that is the idea behind it. Okay, now coming to the next step, that who is going to commit to whom. Okay, I am talking about a special scenario जहाँ पे pardon दिया जाता है under 306. Okay, see, we have seen that there are three classes of magistrates who can give pardon under 306. That is the CJM, the magistrate of first class and the metropolitan magistrate. ठीक है, अब इनके पास different situations होती हैं और उसमें how will they act, we'll discuss this. See, the metropolitan magistrate or the magistrate of the first class, these two, if a case comes before them and they are giving pardon to the accomplice, then whom they will commit the case to? They will commit the case to the court of session if the offence is exclusively triable by the court of session. ठीक है? If the offence is not exclusively triable by the court of session, they will commit the case to the chief judicial magistrate. Understood? See, 306 specifically provides that the magistrate who is giving pardon shall not try the case himself, even if the case is triable by him. Okay, there is the bar created by section 306. In other cases, जहाँ pardon नहीं दिया जाता है, वहाँ तो obviously if the offence is triable by that magistrate जिसके पास case आया है, that magistrate will try in the normal course. Okay, but in a situation where the magistrate has given pardon to the accomplice, उन situations में even if the offence is triable by the magistrate, वो try नहीं कर सकता. He has to commit the case to the either court of session or chief judicial magistrate, as the case may be. I already told you that if the pardon is given by the metropolitan magistrate or the magistrate of the first class and the case is where the offence is such that it is punishable exclusively by the court of session, तो वो court of session को commit कर देंगे. And if the offence is not exclusively triable by the court of session, they will commit it to the chief judicial magistrate. Okay, now अगर केस चीफ जुडिशियल मजिस्ट्रेट के पास आया है तो वो क्या करेगा? Chief Judicial Magistrate in all scenarios has to commit the case to the Court of Session, irrespective of the fact कि the offence is exclusively triable by the Court of Sessions or not. Understood? Even if Chief Judicial Magistrate is empowered to try the case, he will not try it because 306 में bar है that the magistrate giving pardon shall not try the case himself. So, in all circumstances, in all types of cases, the CGM will commit the case to Court of Sessions. See, this is a deviation. Normal course में नहीं होता है ऐसा, but जब pardon दी जा रही होती है, तो he will do it. Okay, I hope this entire matrix is clear to you all. When who is empowered to give pardon, and for what offences the pardon is given, and who will commit the case to whom. These are the essentials of 306. Okay, now coming to 307. I already told you 306 applies to where the pardon is being given before the committal. Okay, now suppose a situation is there that a case comes before the magistrate sees, okay, this is the offence pertaining to an offence which is exclusively triable by the Court of Session. He complies with the provisions of 207 and 208 of CRPC, and then under 209 he commits it to the Court of Session. ठीक है, अब तो क्या कोर्ट ऑफ सेशन पार्डन नहीं दे सकता, यहाँ मजिस्ट्रेट ने पार्डन नहीं दिया है. ठीक है, 306 हैज़ नॉट कम इन टू प्ले. Okay, so magistrate has under 209 committed the case to the Court of Session. क्या Court of Session pardon नहीं दे सकता? दे सकता है. Under 307 वो दे सकता है. Okay, what does 307 says? कि 307 empowers the court जिसके पास कोई भी केस by committal आया है. That court could be a court of sessions, that court could be a court of chief judicial magistrate or any other court. कोई भी court enumerated नहीं है, named नहीं है वहाँ पे. Any court जिसके पास कोई भी case by committal आया है, that court can give pardon if it deems fit under 307. Okay, I think this is clear. Now, this was the first aspect of accomplice. Accomplice कैसे बनते हैं, कौन होते हैं, कैसे उनको pardon मिलता है, कैसे examination होता है. Now coming to another aspect, that what about the testimony given by the accomplice? What is the evidentiary value of that testimony जो accomplice देता है as a witness? Okay, तो उसके लिए we'll have to deal with two provisions of the Evidence Act. Now we have come to the Evidence Act. Okay, what are those two provisions? Those two provisions are Section 133 of the Evidence Act and Section 114 subclause B of the Evidence Act. I'll discuss 133 first. Okay, what does 133 say? 133 says that an accomplice shall be a competent witness against the accused. Okay, and a conviction is not illegal merely because it is based on the uncorroborated testimony of the accomplice. Understood? See, it actually empowers the accomplice to give evidence against the co-accused. Okay, हमने अभी देखा that accomplice कौन होता है. Accomplice is a person who has been privy to the crime, he has been party to the offence, party to the crime, but he has not been made co-accused. या तो उसको चार्जशीट नहीं किया गया है, या उसको पार्डन मिल गई है 306 या 307 में, और either he has been discharged or he has been acquitted. तभी वो टेस्टिमनी दे सकता है. Okay, so what does 133 evidence says? That 133 evidence makes the accomplice a competent witness. That means वो witness, as a prosecution witness, he can give evidence, he can give testimony in favor of the prosecution against the accused. एक accused, दो accused, जितने भी accused बने हुए हैं उसमें. Okay. And it also empowers the court to convict the accused on the basis of the evidence given by the accomplice, even if it is uncorroborated. मतलब solely what does 133 says? It empowers the court to convict the accused solely on the basis of the testimony of the accomplice. Okay, ये हो गया. Now come to 114b. What does 114b say? 114, if you know, talks about the presumptions. ठीक है? It says the court may presume these facts. Okay. कौन से facts? अब B क्या कहता है? उसका clause B क्या कहता है? उसका clause B के according, the court may presume that the accomplice is unworthy of credit unless he is corroborated in material particulars. Okay. Now this is saying something different. A thing which is different than what 133 said. 133 ने तो बोल दिया कि हाँ, he is a competent witness and court can convict the accused on the basis of his testimony. But यहाँ पे 114 what it is doing, it is empowering, or rather say it is enabling the court so as to presume that the accomplice is unworthy of credit. Okay, so what is the current practice? We see there are two different type of provisions in the Evidence Act. So what is the crux coming out of reading these both the two sections? See, the courts in practice, what they do is they rely upon both the sections. Okay, they accept, yes, that 133 says that the accomplice is a competent witness. Okay, he can give evidence, but the courts take a caution in convicting the accused solely on the basis of the testimony of the accomplice. Okay, and they also take into account the section 114b and this okay, accomplice has given the testimony, but that must be corroborated at least in material particulars with the other evidences. Okay, we have different cases wherein the courts have reiterated the similar things. First one is Ravinder Singh versus State of Haryana. It says that the accomplice is the most unworthy of friend, if at all it is. Okay, because he has bargained for his immunity, and then he must prove his worthiness for it. Okay, he was a friend, he took part in the crime with the accused, he collaborated with the accused, but जब अपनी सजा की बारी आई तो he has taken pardon from the court, and that's why he is a very unworthy friend. Therefore, a person who is a very unworthy friend, you must not convict the accused solely on the basis of his testimony. Okay. And then we have other cases as well. This was Ravinder Singh's case. In other cases also, the court has said the similar things. Okay, that the testimony must be corroborated. I'll tell you the two cases. That is Khokan Giri versus State of West Bengal, AIR 2017, and Mrinal Das versus State of Tripura, AIR 2011. Okay, so what we have discussed in here, we have discussed as to who an accomplice is. Sometimes the word accomplice is interchangeably used with the word approver. Okay, once he is given the pardon, he is called the approver generally, normal parlance. Okay, so we have seen who is an accomplice, how he is given pardon under 306 and 307, and how he is examined before the committal of the case, that is also under 306. And then we have also seen that what is the worthiness of the testimony given by the accomplice. I hope I have made things simpler and clearer for you. Thank you.